Now, my name is Daisy DeKelmer and I'm Manager for Sector Development here at the Queensland Council of Social Service. And human rights in action webinars are something that we've been doing for quite some time now. Ever since the implementation of the Human Rights Act, QCOSS has been really interested in how we build the capacity of the community services organisations across Queensland to fully embed the Human Rights Act in their frontline work, in their policy, in their practice. So over the years, we've hosted quite a few human rights in action webinars that have explored a number of topics, sometimes related to submissions or reforms that are happening, and sometimes related to things like our practical skills around upholding and respecting human rights, respecting culture across our service delivery across social services. So today's session is really around assisting building the capacity of non-legal advocates to use the Human Rights Act as a mechanism for advocacy in their work. And I know that that's something that many organisations have been doing, some better practice than others. And so we're really fortunate today. We'll be hearing from Karen from the Queensland Human Rights Commission around that mechanism of using the Human Rights Act in advocacy. We'll also be hearing from Matilda from QII, who's going to be speaking to us about some real scenarios where they have been able to use the Human Rights Act in their advocacy work. So some great things to hear about today, which is why we're hosting a little bit of an extended session today. We try and keep these to an hour usually, but I think there was just too much ground to cover today. So we've made it an hour and a half to get through all of that good stuff. Now, before I hand over to Karen, who is going to start the presentation and sharing her content, what I'm going to do first is acknowledge the Yagara and Turrbal people. It's on their land that QCOSS does a lot of our work in Brisbane, and I'm today on the fringes of the Yugambeh speaking nation and near Logan. So I'd like to pay my respect to elders past and present. I acknowledge that QCOSS as an organisation is doing some work at the moment to support a successful referendum to enshrine a voice in Parliament. And as an organisation, we really want to put forward our support of that and acknowledge any First Nations people on the line. Okay. I'm going to thank Matilda and Karen in advance for the work that they have done in preparing for this session. We're really fortunate to hear from your expertise and hear about your experiences in using the Human Rights Act. And I'm going to hand over to Karen. Karen, thank you very much.
Thank you very much, Stacey, for organising the session. It's been great in setting us all up on this. Hopefully everyone can hear me okay. Give me a nod. That's excellent. I'm just going to share a PowerPoint in a moment, but I'll just first let you know. So my name's Karen Menashe. I'm one of the Senior Community Relations Officers at the Queensland Human Rights Commission. I've been with the Commission for 14 plus years and doing this training for advocates, for community advocates since 2020. I developed the 3-hour session for community advocates. So what I'm doing today is just a snapshot, I guess, of that session. And if you're interested in a more sort of interactive session where you can discuss your own organisation scenarios, etc., please feel free to contact us. Just be aware that this is a snapshot of that session. So I'm just going to quickly share a PowerPoint with you. And I'll be going through that today. And also, please be aware, folks, I'm not a lawyer. I'm an educator. I started out as an ESL teacher, an English as a second language teacher. And it's really important to understand that you don't need to be a lawyer to be able to use the Human Rights Act to advocate on behalf of people or help people advocate on their own behalf. That's a really important place to start in terms of advocacy, if you're a community advocate and not a legal advocate. So I'd like to start by acknowledging the traditional owners of the land on which we meet, and here in Brisbane, that's the Jagera and Turrbal peoples. There may be other peoples if you're in other parts of the state that you'd like to acknowledge, please feel free to put that up on chat. I think Stacey's going to be watching the chat box. I probably won't, as I've got quite a bit to get through in the hour that I've got. And I'd like to acknowledge elders past, present and emerging, and just bring to your attention that the relatively new Human Rights Act enforced from the 1st of January 2020 in Queensland acknowledges the particular importance of First Nations people and recognises that in a separate section of the Act, Section 28, Cultural Rights for Aboriginal and Torres Strait Islander peoples. That's the first time in human rights law in Australia that that's been acknowledged in a completely separate section. So today, a very brief review of the Human Rights Act, looking at why advocacy is so important for the Act. Just thinking about how you identify when protective rights have been limited, how you assess compatibility with human rights as an advocate. You need to be able to do that, and I'll explain why. And then how you actually use the Act to advocate on behalf of clients and what our complaints process looks like. And we'll start with these topics first and then go on to the second part. So the Queensland Human Rights Act, the objectives of the Act. So it was so from the 1st of January 2020, it was enforced. In other words, from that point onwards, we were able to accept complaints under the Human Rights Act for anything that occurred on or after the 1st of January 2020. And the objectives of the Act are to protect and promote human rights, which is fairly self-explanatory, to help build a culture in Queensland public sector that respects and promotes human rights. So a few things I'd like to say about that. When we talk about the Queensland public sector, we're not just the Act doesn't just refer to government. It's broader than just government, and I'll talk a bit more about that in a moment. And there's nothing, it's not saying that there is no culture of human rights in the Queensland public sector. Of course there is, and human rights are embedded in many of the pieces of legislation that drive us all in our work. Including in the public sector or in the sector that supports the public sector. But what it is saying is that we can certainly improve. There's room for improvement. And in some areas, there's more room for improvement than in other areas. So there are areas of more concern than others. And what I'd like people to see, public entities, if it's government, if it's NGOs, I'd like people to see the Act as a tool to help them improve their practices and their services, their service delivery in terms of human rights. So, it's a really useful tool if it's used that way. And I'll just show you how it can be used that way as we go through this morning's session. And it's there to promote a dialogue about human rights. This is a really important point. It's not a model of law, it's not a litigious model of law. It's not aiming to get people into courts and tribunals and fight things out for an outcome. What it's aiming for is to get people to talk to each other, people to talk to the public entity that they feel has limited their human rights in an unreasonable way, and enter into a genuine dialogue. And it's encouraging the public entities to enter into genuine dialogue with people to try and resolve an issue. And that's built into the Human Rights Act complaints process, which I'll go through towards the end of today's session. And the Act recognises the inherent dignity and worth of all human beings. So it's worth noting that any human being in Queensland is covered by both our pieces of legislation, Human Rights Act and Anti-Discrimination Act. And so no matter what people's visa status is, you can be talking about a tourist, you can be talking about an asylum seeker, you can be talking about a citizen or a resident. Everyone has the same rights under our legislation. And the dignity, respect, and of human beings across the planet is really important in terms of understanding human rights. And also it's important to note that only human beings, only individuals have rights, not corporations. So why advocacy? Why do we need advocacy? Well, first of all, the Queensland Human Rights Commission can't do it all on its own. We're less than 60 people. We're growing, but we're around 60 people across the whole state. Of course, we can't reach everybody. And so it's really important to get advocates on board to understand how the Act works and to understand how to apply it to situations and recognise when it does apply and how to apply it. So to fulfil the objectives of the Act, which I've just mentioned, that dialogue needs to take place between the individual, the person who believes that their human rights have been limited in an unreasonable way, and the public entity that has done that, that has limited their rights. And a lot of people, first of all, don't even understand that they have those rights and that they can do that. And second of all, they will often need advocacy assistance in that dialogue process. Now, they might need it just, you know, for you to help them understand what their rights are and how they can approach the public entity, or they might need for you to perhaps do it with them or on their behalf. Depends on the individual, and you'll be able to tell that with the person that you are dealing with. I'd also like to say you do not have to have advocate in your title to be able to be an advocate. If you're working in the community sector, if you are working with people who are vulnerable, and people who have experienced some kind of unfair treatment, if you feel that you recognize that perhaps their human rights have been limited in an unreasonable way, and you might be able to help them understand this and do something about it, then you become an advocate. And advocacy for individuals often can lead to better human rights outcomes for that person, but also very important to note, in the longer term, it can lead to systemic change. So I know that community advocates do sometimes get disheartened and disillusioned. You know, they feel like they're banging their heads against a brick wall, but be aware of the fact that, and I will give you some case studies at the end of the session about, you know, how advocacy has worked in other jurisdictions. And please know that in other jurisdictions such as Victoria, the ACT, or the UK or EU, human rights advocacy has helped to eventually lead to systemic change. So it's a drip, drip, drip effect. Think of the stalactite and the stalagmite meeting at the end of the day after millions of years. Well, not millions of years, but your drip, drip effects, you know, collectively will eventually lead to systemic change. So it is really worthwhile putting in the effort, even when you feel like you might be banging your head against a brick wall sometimes. These are the rights that are protected by the Queensland Human Rights Act currently. So we have 23 sections of rights, and the reason why we say 23 sections of rights is because under each section there are often multiple rights. 21 sections of civil and political rights that are drawn from the International Covenant of Civil and Political Rights under the UN. That's sections 15 to 35 of the Act. And then there are two sections of economic, social and cultural rights, sections 36 and 37, drawn from that international covenant. And that's the right to education and the right to health services. And what's worth noting, particularly about those, is that we are the first jurisdiction in Australia to include the right to health services. We are the third jurisdiction in Australia to have a Human Rights Act, piece of law, full stop. So, you know, some people think we have a Human Rights Act at the federal level or a Bill of Rights at the federal level, but we don't. This government is starting to talk about it, which is really, really good news. But the more and more states and territories that have these pieces of legislation, ACT from 2004, Victoria from 2006, I believe, and we are now from 2020. And so again, it's only individuals that have rights, not organizations or corporations. In terms of these 23 sections of rights, I think what is really important for you, and I've sent you a handout to be sent to you after the training today, a handout of what rights are protected in the Act, and that's word for word how they are worded in the Act. What's important for you is to identify those that will pop up again and again in your line of work for the people that you deal with in your line of work, and get to know those ones very well. So you might have to get to know 8 or 9 of them very well, get to know the subsections, you know, not just the headings of them. These are just the headings that are appearing here today. But if you think that, you know, privacy and reputation, section 25, or freedom of expression, section 21, or cultural rights for Aboriginal people, Torres Strait Islander people, section 28, humane treatment when deprived of liberty, section 30. If you think those ones are very relevant to your work, get to know them well. And of course, always look out for, you know, understanding, identifying rights that are protected or limited, and improving your knowledge of them. So who has obligations under the Human Rights Act? It's important for you to understand how the Human Rights Act works, because if you are going to use it in supporting someone with advocacy and trying to get an outcome for them, you know, in discussing with a public entity, you need to make sure that you actually accurately assessing a situation in terms of whether or not it is covered by the Human Rights Act at all, and whether and how it's covered. So it's really important that you get to know, that you sort of understand how the Act works. So who has obligations under the Act? Parliament has, all three arms of government have obligations under the Act, and I'll also talk about some more organisations. So Parliament, from the 1st of January 2020, every new piece of legislation that's introduced as a bill to be voted on in Parliament must come with a statement of compatibility with human rights, which will state where, if and when and where this bill is not entirely compatible with human rights. And that just gives people the opportunity, so members of Parliament who are voting on it, members of the public who are making submissions on it, to know quickly where human rights concerns might sit in that bill, and to make comment on it or request adjustments, amendments, etc. That doesn't mean to say it can't be voted on. Parliament remains, it can vote that bill still into law, but the commentary, it's transparent, and the commentary can take that transparency into consideration. Courts and tribunals from the 1st of January 2020 must interpret laws in a way that is as compatible with the Human Rights Act as possible. Obviously, they might need to sentence someone to a stretch in corrective services and take their, restrict their or limit their freedom of movement, but they will have to do it that in the way that is, and that is as compatible as possible with the Human Rights Act. And today's focus is public entities who must give proper consideration to human rights when making decisions, and always act and make decisions in a way that is compatible with human rights. And I'm going to unpack that for you. So public entities, first of all, who are they? Core public entities, those are Queensland Government departments, Queensland Government ministers, all staff, all Queensland Government staff, Queensland Police, emergency services, etc., and also local government councils, councillors and all staff. And we, and I say we because I'm one of them, have obligations under the Human Rights Act at all times in the course of our work, not in our private life, but anything we do in the course of our work, we have to consider human rights, and we have to try and make sure that we are acting compatibly with human rights. Then there are functional public entities, and those are organisations, possibly yourselves, your organisations. You often non-government organisations, sometimes maybe private organisations. When they are performing functions of a public nature, they will be public entities and will have obligations under the Act, and I'll talk about those obligations. So you might have an NGO that's delivering disability care support services or out-of-home care for children, residential care for children, or for aged care, residential aged care facilities, those kind of things. So in those circumstances, in that situation, they would be, when delivering those services of a public nature, they would be public entities. Or you might have a private bus company delivering services on behalf of the Department of Transport and Main Roads. When they're delivering those services, then they will be considered public entities and will have obligations under the Human Rights Act. And you've got opt-in entities as well, organisations that can request to have the obligations under the Act. QAI, I know Queensland Advocacy Incorporated has requested to be a public entity. There is one other organisation that has requested. I'm not sure if it's actually public knowledge yet. So, but they can ask for the obligations in writing to the Attorney General. So what are the responsibilities of public entities, whether functional or core? They must always give proper consideration to human rights when making decisions, and act to make decisions in a way that's compatible with human rights. So let's look at what that means. Section 58 of the Act talks about what proper consideration means. And that says that the public entity, when making a decision, must identify if any human rights have been affected by the act or the decision. Now, that could be protected or limited. And they have to consider the impact, and they have to really think about where the rights might be limited. in particular. So you might see a situation where we're going to talk, I'm going to put some scenarios forward to you later on where you'll see that rights can be both protected and limited at the same time, or there might be differing opinions on whether the right's being protected or limited. If there's a child safety situation where a child is being removed from a family, the department is doing that because it believes that it's protecting the child's possibly right to life, right to education, right to health services. The family might not agree and might believe that what's in the child's best interests, Section 26(2), under the Protection of Families and Children, is not being protected. They might disagree with that. So you might have differing opinions on whether the rights are being protected or limited. And if the public entity identifies, that they have limited human rights, then they must think about whether the decision is compatible with human rights. And we're going to look at what that means. And it's really important for you to be able to do that assessment, because you don't want to go in and advocate for an individual without really being sure that you don't actually understand the public entity's point of view first and foremost before you go in to advocate, because the public entity may have had good reason to limit the person's human rights. So we're going to talk about that. But the purpose of proper consideration is to help public entities improve their decision making. So before they actually act on any decisions, you want to make sure the Act makes sure that the public entity wanting to restrict or planning to restrict a human right will really think very, very carefully about whether the decision and the actions ensuing out of that decision will strike the right balance between the person's rights and the other broader considerations. So going back to that child safety scenario, the broader considerations are the safety of the child, and making sure and also making sure that the department itself does not neglect that child's rights, but then there's the individual's rights and the family's rights to balance out. So it's always a balancing act in terms of human rights. You might also have a situation such as COVID, where our freedom of movement was significantly curtailed in some situations at some moments in time, and that the broader considerations were the government felt that the risk to the public health risk was too great and necessitated the curtailing or the limitation of our individual rights of freedom of movement. So again, there's that balancing act that happens. So how do we assess compatibility with human rights? And if an act or a decision, a statutory provision, a policy, a practice, whatever it is, does not limit a human right, if we sort of done that proper consideration, no, we don't think a human right has been limited, well, then we're acting compatibly with human rights. But if we identify that our actions are going to limit a person's human rights, then it must be only to the extent that is reasonable and demonstrably justifiable. And Section 13 of the Act gives us a little bit more information on that. And that word demonstrably is very important, both for the public entity and for you as advocates. It means the public entity must be able to show its thought process, how it reached the decision that their actions in limiting a person's human rights were reasonable and justifiable. It also means that if you, the advocate, ask for information on why they think it's reasonable and justifiable to limit a person's human rights, they should be able to provide that information to you. And we'll look at some other ideas from the ACT and from other jurisdictions who also talk about, what you can do as an advocate in terms of the steps you can take, and they also talk about that. So Section 13 of the Act gives a little bit more guidance on how to assess compatibility. So in order to decide whether a limitation of a person's human rights is reasonable and justifiable, the public entity must consider the following things. So they must think about the nature of the human rights limited, and the impact on the individual. How serious, what's the impact going to be on this individual by limiting their human rights? They've then got to also think about the purpose of the limitation. Why are they doing this? What's their purpose? What are they trying to achieve by limiting this person's human rights? And how important is it that they achieve their purpose? And they've got to think about the relationship between the purpose, that what they're trying to achieve, and the limitation, and think about whether it's proportionate. And I'll give you a scenario in a moment that sort of discusses that idea of proportionality. And it comes back to that balancing act, of course. But the important thing they've really got to think about is there a less restrictive way for them to achieve the purpose? So the public entity always has to think about what's the least restrictive way I can achieve my purpose that's reasonably available to me. If I need to limit this person's human rights, if my purpose is legitimate, how can I do so in the least restrictive way reasonably available to me? And they've always got to think about that and go to that least restrictive measure first up. And so that's another thing that you can think about is, sorry, I'll just go back to that quickly. If you identify as an advocate that the public entity has the legitimate purpose, then what you can do is think about, well, yes, maybe they have a legitimate purpose, but possibly I think that they might have they've taken extreme measures and then they could actually do something less restrictive and still achieve the same purpose. And again, I'll talk that through with you with the cases. So again, coming back to that balancing act in terms of assessing compatibility, the public entity has to think about, has the importance of the purpose of their purpose, what they're trying to achieve, been balanced correctly with the idea of preserving the human right. And so they've really got to think about that balancing act and think about proportionality and think about all the competing private and public interests and obligations and competing, human rights, and think about whether they've got the balance right. So the practical steps for assessing compatibility with human rights that have been developed together with, before the Act came into force, together with us, together with the Department of Justice and Attorney General. And so the first step is to identify which rights are relevant, protected, which rights are engaged at all, and whether any of them have been limited for that individual. So there might be situations where protected and limited, as I've said before. And then if they identify that rights have been limited, is the limitation reasonable and justifiable? And to get a practical kind of way of assessing that, they came up with these 5 questions. First of all, you've got to ask themselves, is it lawful? Is there some piece of legislation or legal framework or legal authority that allows them to limit a person's human rights in this way? Now, if there is no legal authority, and we're not talking policy, folks, here, we're talking legislation. If there's no legal authority that allows them to do this, or legislation or regulations, then it's probably, their actions are probably not compatible with human rights. Okay, they've identified that it's lawful. Is there a legitimate purpose? Is it rational? Does it actually achieve the purpose? Is it necessary, or is there a less restrictive measure reasonably available to them? And at the end of the day, does that balancing act work well? Is it fair and balanced? Do the benefits of achieving the purpose outweigh the harm? So let's look at a quick case study from before we move on to the other case studies. From Victoria, it was a hearing about a young woman who was apprehended in a busy train station in Victoria. She was approached by 3 security officers who believed that she did not have a valid train ticket. And they were authorized to detain her until the police arrived when they could search her. So they did have legal authority to do it. And they did have a legitimate purpose in detaining her, because the purpose was to uphold the law, which says we all have to pay for our public transport. Otherwise, we wouldn't be able to afford public transport. But the way they did it. So how they did it was they approached her and then they spear tackled her to the ground and held her face down on the ground for about 8 minutes until the police arrived. Yes, they had a legitimate purpose, and they probably, was it rational? Well, did it effectively achieve their purpose? Well, it did achieve their purpose. She wasn't going anywhere until the police arrived, but was it proportionate? So CCTV footage of the incident and witness footage, because people filmed this because they were quite shocked, showed that the young woman had no weapons. She wasn't presenting any risk of harm. to the officers, and that they did have a less restrictive way reasonably available to them to detain her, which was probably just a stand around her. There were 3 of them and 1 of her, and ask her to wait while the police arrived. And it would have been unlikely that she would have been able to run away. Now, what rights were limited? She argued that her right to protection from torture, or the equivalent in our act is the Section 17, protection from torture, cruel, inhuman, and degrading treatment. So she felt it was highly degrading, humiliating for her to be held down, face down on the ground for in front of many people for 8 minutes, which is a long time in that situation, like a dangerous criminal, when all she'd possibly done was not have a valid train ticket for $5. So her rights were limited, and it was deemed to be not necessary because there was clearly less restrictive measures reasonably available to them to achieve their purpose, and therefore it wasn't considered to be fair and balanced. So this is sort of the process that you would use if a client came to you with concerns and told you their story. You would need to start assessing compatibility with human rights. So first of all, identifying whether it was a public entity that did whatever happened to the person. So coming back to that idea of who's a public entity, you need to also know that Commonwealth agency, for example, is not a public entity. A private hospital or a private school is not a public entity. So it's important to identify whether a public entity indeed is involved at the start, and then to try and assess compatibility. And of course, you'll also probably have to get the public entity's information to really be sure that you're assessing compatibility in an accurate fashion as possible. So let's think about how advocates have actually used the human rights legislation, and I'll be giving you examples from Victoria, from the ACT, and I think also I may have one from the UK. It's important to note that the Act also tells us, the Human Rights Act also tells us that we can refer to other jurisdictions to understand, to assess compatibility, to understand proper consideration, etc., because this is a very new piece of legislation in Queensland. And so the Act does actually tell us that we can refer to international or domestic legislation in other jurisdictions to help us understand how the Act might apply to a particular situation. So I'm also going to talk you through the complaints process and what some options and remedies are that are available to an individual. Okay, so I also want to talk to you, so before we actually go into some of the case scenarios, the Human Rights Law Centre has some fantastic advocacy guides based on the application of the Victorian Charter since 2006. They've got some really great case studies, and they're really worthwhile. And I think there's 8 guides, and they're based, and there might be more since I last looked, but they're based on industry sector, which sort of broken up in industry sector, so disability, Aboriginal, Torres Strait Islander peoples, etc. So that's really useful, and they're certainly worth having a look at if you're interested in advocating and using the Human Rights Act. So what advice do they give? I've talked you through the steps that we recommend using to assess compatibility, but they're talking sort of more broadly, what do they recommend when doing advocacy work? And you'll see how it's very similar to what I've been talking about. They recommend that first of all, identify whether the act or decision or whatever it is that's causing a problem for the person you're advocating on their behalf, your client, whatever you want to call them, are they a public entity? Is a public entity responsible? And that's a really important first step, as I've said, because if it's not, if a public entity is not responsible, you can't use the Human Rights Act in your advocacy work. You can obviously use other tools to advocate, but not the Human Rights Act if it's not a public entity. If you've identified a public entity, next thing, identify which human rights may have been limited. There's often more than one. And also you want to identify the public entity's purpose. Now you may need to communicate with them to find that out, and you identify whether you think they've got a legitimate purpose in doing what they're doing. But then if you do identify if they've got a legitimate purpose, can it be achieved in a less restrictive manner, as I've already said. Once you've gathered all the information together and you've identified what would be the desired change, the less restrictive measure that is reasonably available, and that's reasonable for the public entity to consider, given the situation. Then consider how you're going to communicate with them and raise the issue with them. And then, of course, if there's no resolution within 45 business days, and this is written into our complaints process under the Human Rights Act, then you can think about a complaint to a body such as the Queensland Human Rights Commission or the Queensland Ombudsman and other organisations, or Health Ombudsman, whatever you feel is relevant to your client's situation. Now, the ACT, which is the first jurisdiction in Australia to get a human rights piece of law, also gives us some guidance on how to advocate, how to use the Human Rights Act to advocate. So you can see all of these other jurisdictions believe that advocacy on behalf of legal or community advocates is also very important to support the Act and make sure that the Act actually has impact in the community. And so they have a web page called Achieving the Rights Outcomes, and they've got an attachment called Preparing to Advocate, and I've taken some steps from them as well. So they sort of asked you to think about, first and foremost, what are your clients' expectations for a reasonable outcome? And this is important because you will find that some clients don't have reasonable expectations of what they might be able to achieve. You, as an advocate, will be able to, once you know what the public entity was trying to achieve, whether they had a legitimate purpose, you'll be able to, more unemotionally than the client themselves, perhaps step back and maybe assess, a little bit more clearly what a reasonable outcome, what could actually be achieved for that person. So they might want an outcome that after hearing from the public entity, etc., you think, look, I don't actually think that they're asking for something that's really achievable or reasonable. Part of your job might be to help them have more reasonable expectations, because if you go in for advocacy work and you go charging in there with unreasonable expectations, it's just going to, the advocacy work is going to fail. So you want to make sure that you've got that right for a start. If there is a law that permits the public entity to limit the person's human rights, find out if there's any discretion within that legal framework. If there is discretion at all, that means that possibly they can limit the rights in a less restrictive manner. If there's no discretion at all, well, and if you think that they've got to apply that law, well, then possibly there may be nothing to do about it. But you've got to try and find that out from the public entity. And then think about whether the public entity interpretation of what's compatible with human rights, if you agree with that. If you don't, then you might want to raise that with them. Always ask the organisation, the public entity, to demonstrate why and how they believe that their action or the decision was a proportionate limitation of the person's human rights. That's written into the Act. It must be demonstrably, reasonably and demonstrably justifiable. So you can ask them to explain why they think the action or decision is a proportionate limitation of the person's rights, and that will give you more information to work with. And then, make sure that you consider all your resources, draw up a plan before you go in, and make sure that you consider how you want to start communicating with the public entity. If the person's been communicating with the public entity effectively for ages, you might think, well, let's raise it to the next level. Clearly, they're not going to. There's no outcome achievable with where they've been communicating at the level that they've been communicating to this point. And please, folks, I know that sometimes you do get very frustrated, but concentrate on the problem, not on the person. So public entities, staff are often overworked, under-resourced. I'm not giving any excuses for when people are limiting human rights in a way that you might feel is not entirely reasonable. But you really want to be genuinely open to hearing what the public entity's purpose was in limiting the person's human rights. So you want to really be, develop a decent relationship with them, have good good communications, respectful communications with them, because you need to know what their thinking is in order to be able to advocate effectively on behalf of your client. So even when you're feeling really, really stressed out, no, I'm not getting anywhere with this person, just try and remain calm and courteous, and just try, because you're trying to mine information that will help you in your advocacy work with them. And of course, at the end of the day, if you think, well, look, this public entity is just not hearing at all, if you've reached the end of the 45 business days that you've been trying to negotiate with them, you can consider a complaint to the Queensland Human Rights Commission or other relevant agency. So let's have a look at a few case studies that I've got for you to hopefully will illustrate how all of this works. So the first one is from Victoria. And this was a refugee family, a large family, 7 people, that had arrived in Australia and really had problems getting financial support and housing. Probably the fact that they were such a large family probably didn't help, but they were having a lot of difficulty. And so they finally got some permission to sublet a public housing property. Somebody was going away for a while, and so they were able to sublet that property for a while, but that tenant returned and they had to vacate the property. A while later, there was a fire at the property, and the property was fire damaged, and that the tenant actually vacated, and they found out about it and they moved back in. Because they just had no other options. They were really desperate and at the end of their tether. And so they moved back in. They didn't get permission, but then they contacted the Office of Housing immediately to ask for permission. But the Office of Housing was not open to hearing anything and said that, they just had to be removed. They would be removed. So if you think about it, the steps that you would go through in trying to look at this. So what rights, were their rights engaged? Well, their right to protection of families and children. So obviously it's in the best interest of the family and the children to have a roof over their heads. Privacy and reputation. So the person's, not the right not to have the person's home or family arbitrarily or unlawfully interfered with, possibly even property rights. Those property rights have been shown to apply in situations when a person's home, even if they don't own that property, is interfered with. But possibly also the Office of Housing, if that property has been really seriously damaged by fire, perhaps they think they're protecting these people's right to life and safety, and security. So because they feel it's unsafe to live there, so there's a bit of balancing of rights going on there. But the family contacted the homeless person's legal clinic for assistance, and the homeless person's legal clinic got involved with and contacted the Office of Housing, and stated that under the Charter of the Victorian Charter, protection of children and families, as I've mentioned, the right to property and freedom from interference from a person's home, which in our Act would be Section 25, privacy and reputation, were being limited. And then they entered into negotiations with the Office of Housing, and clearly what ensued through the negotiations that ensued, eventually the Office of Housing allowed the family to sign a tenancy agreement for that property. So clearly the fire damage wasn't so great that it was risking serious harm to the family if they lived there and things were fixed up and they were able to live there. So the moment the homeless person's legal clinic, who was, they were versed on the Human Rights Act, they were able to get to intervene and assist, then the Office of Housing obviously sat up and thought about, okay, here's somebody who has someone assisting, who knows the rights and who will understand the Act, and will have to enter into negotiations or dialogue with them. And they reached an outcome that was satisfactory to everyone. So an example from the ACT. So this was a resident in an aged care facility. He had a wheelchair which was battery operated. the staff concerned about how he operated the chair and moved around the pathways around the aged care facility. They felt he wasn't entirely safe in doing so, and that he was maybe dangerous to himself or others if he fell off a path and hit his head, for example, or if he ran into other people in the aged care facility, he might harm someone. And so they decided that the way to solve the problem was to remove the battery from the chair, and he wouldn't be able to move around very easily or at all without assistance. And so this did make it very difficult for him to move around freely without assistance, and obviously limited his independence quite significantly. So he had an advocate who then argued on his behalf that it was a breach of his right to freedom of movement. So they raised the right to freedom of movement, and in the negotiations, first up, the battery was returned to the man's wheelchair so that he could operate it himself. And then, but the advocate also recognised that the facility had some legitimate concerns. That there was a safety issue there. There was a legitimate safety issue there, and they had a legitimate purpose in trying to keep the person safe, the man safe, and others around him who lived around him safe as well. And so they also recognized that they had to then sit down with the facility, with the staff at the facility, and with the man to try and work together to find to support the safety issue at the same time, but then to also make sure he was able to move around freely and find less restrictive measures than just completely removing the battery from him to help him be safe, but also be a bit more independent. And so what this included was a bit more support around using the footpaths safely, and perhaps, maybe in some places he would be more guided than others, but helping make sure that he was safe and others were safe, but he could still move around and, for example, go to the shops if he wanted to on his own. And so they reached that compromise of those less restrictive measures. The next case I'm going to talk about was a case which involved domestic violence and child safety. And this was in the UK. And you can find this in, and by the way, folks, you'll be sent copies of these and the sources where you can find these scenarios, these cases, the sources identified in every case in each slide. So this is from the British Institute of Human Rights, and it's based on the Human Rights Act, the UK Human Rights Act. So this is about a woman living in poverty with a violent partner, with a partner who she discovered had been abusing her children. And of course, when she discovered this, she then tried to move away. She asked for assistance, and she was placed by social services or something of the equivalent. They placed her in temporary B&B accommodation because they couldn't find permanent accommodation for her or other shelter accommodation for her. But they kept on having to move her. So she was moved around various accommodations in 3 different London boroughs over 6 months. Now, London boroughs are like our local council's areas, but London's very large, as you can imagine. And so, she found it really difficult to get her children to school, moving around so much and sometimes being far away or keep them in the same school. It was really difficult for her over those 6 months. So to the point where eventually the social workers saw what, that she wasn't really managing to get her kids to school in time, moving around. And they decided that they would have to take the children into care. And they said that she was an unfit parent because she was unable to provide stability for them and was having difficulty getting them to school. Well, she obviously felt that this wasn't fair. It wasn't because she wasn't trying to provide stable home for them. She was actually trying to remove them from abuse and trying to set up a stable home for them, which was very difficult for her. And so she went to a local support group, and they helped her prepare her case. So this is a case where she wanted to advocate on her own behalf, but she wanted support in doing so. So they helped her prepare her case for a case conference that came up with the department that was making this decision to remove the children. And with their help, she was able to understand and invoke her children's right to respect for privacy and family life. So would be the equivalent of our Section 25, privacy and reputation, their right to education. So their right to have a stable environment to live in. It wasn't her fault. She wasn't moving voluntarily. She was being moved around. Her right to education and to have a stable place to live so they could near a school, near their school, so they could go to school without problems. And they were asking, basically, they were saying, it's not my fault that my children's right to education is not being upheld. And I would like my, my right to privacy and family life to be respected. And I would like help to secure those rights and through stable accommodation. And so because she had the advocacy group, the support group helping her, the department then recognized that it wasn't her fault that she wasn't actually providing that environment for her children. They decided not to remove the children. They did keep the children on an at-risk register, so they were going to keep an eye on the children. Probably with good reason, because there was an abusive parent on the other that they wanted to make sure that they weren't in touch with that abusive parent or at risk of that with that abusive parent. But very quickly they were able, within 3 weeks of the advocacy, of the case conference, they were able to find stable accommodation for the family, and then even to help them to buy furniture and other goods to set up home. And so, they were able to find a solution for the woman and her children. That was not the extreme measure of removing the children from her care, but there were less restrictive measures reasonably available. And that less restrictive measure was keeping the children on the at-risk register to make sure they're monitored, but not to remove them from her care, and to then support her by finding stable accommodation. So you can see how in all of these 3 cases, the moment an advocate got involved, first of all, the person is feeling a lot less vulnerable. They perhaps know their rights, whereas perhaps before they just felt this is not fair, but couldn't quite articulate what their rights might be, and they couldn't maybe understand how to articulate the argument to the public entity, where the advocate would have helped them do that. So you can see how advocacy work can be incredibly important in these situations. So the Human Rights Act complaints process, the complaint is first made to the public entity. It must be first made to the public entity, unlike our Anti-Discrimination Act complaint process, where we can, if it's a complaint of discrimination, sexual harassment under the Anti-Discrimination Act, we can accept a complaint directly. If we do get a pure Human Rights Act complaint, we will be asking how the public entity has responded to the complaint. If the person tells us, well, they haven't gone to the public entity yet, we will actually refer the complaint to the public entity and ask them to enter into a dialogue with the individual to try and reach some sort of resolution. If the public entity has not responded within 45 business days or has provided an inadequate response, then we may accept a complaint and run a conciliation at the Queensland Human Rights Commission. If we run a conciliation, we are attempting to help the parties reach some sort of an agreement, maybe a change in the policy or change in the practice that's occurred with the client. If there is no outcome at the conciliation conference of the Commission, that's the end of the matter if it is a human rights complaint. If the public entity has provided an adequate response within 45 business days, or we can see that they've given information to us and we feel like they're on the road to actually resolving the issue, even if they're not quite there within the 45 business days, we'll probably leave it to them. If we see that they've entered into a genuine dialogue with the complainant and they're really trying to find some sort of less restrictive measures, or to change whatever it is they've done or reverse their action if it's not at all reasonable and justifiable, then we'll leave it with the public entity to resolve. And another difference with the anti-discrimination between this process and the Anti-Discrimination Act complaint process, that if a complaint is made to the Queensland Human Rights Commission that is a discrimination complaint under the Anti-Discrimination Act, if there's no conciliated outcome at the Commission in conciliation conference, then the complainant can ask for it to be referred to the tribunal or to the Queensland Industrial Relations Commission if it's a work-related complaint. And so, folks, if we recognise at the Commission that a human rights complaint could also be a complaint under the Anti-Discrimination Act, we will let the complainant know, and we would advise them that they could take a complaint under the Anti-Discrimination Act, with the advantages being that we can accept the complaint directly, and they could refer a complaint to tribunal if they got no outcome at conciliation. So options for complaints, starting with an informal communication with the public entity might be the best option, or you might decide that a formal complaint to the public entity is necessary, depending on what's gone on before with your client and the public entity. And of course, there's a option of complaint to the Queensland Human Rights Commission if there's no adequate response within 45 business days. We can also, as I've said earlier, deal with a human rights complaint under the Anti-Discrimination Act if it's relevant, but only with the consent of the complainant. We won't do that without the consent, but we will explain the advantages to them of doing that. We may also refer a complaint to other agencies such as the Ombudsman or the Health Ombudsman, but again, only with consent of the complainant. If the complainant says no, though, and if we really feel we're not the best agency to deal with the complaint, we might actually end up rejecting the complaint. So it is important that the complaint goes to the best agency to deal with it. And there might be what we called piggyback claims. So human rights claim might be argued also. So in addition to an existing right of action in another court or tribunal. So if there's some matter before the courts or tribunal, another matter before the courts or tribunal, and the person feels that their human rights have been limited, they can also piggyback a human rights claim onto that other matter before the tribunal. Or if it's an anti-discrimination complaint that's gone forward to the tribunal, they can then also piggyback their human rights claims onto that anti-discrimination complaint, discrimination complaint before the tribunal. So human rights can be raised if there is another matter before the courts, but they can't, or the tribunal, they cannot raise, there can't be in Queensland a human rights complaint raised independently in the courts. And often people want some kind of acknowledgement that some wrongdoing was done, an apology, an acknowledgement. They often might want a decision to change, a reversal of a decision or a change to a decision or action so that there is some sort of improvement or change to their circumstances, some agreement to provide a service or a practice or a policy that perhaps wasn't provided when they felt it should be, or to change policies or procedures. That's, I guess, more at the sort of systemic level. And if there is an unresolved conciliation at the Queensland Human Rights Commission, then our annual report will probably might contain steps that the public entity could have taken to ensure that their actual decisions were compatible. We might provide a report. We will provide a report to the public entity if there's an unconciliated outcome, and we might include also some recommendations to them. And in extreme cases, then it might actually be published on our website. So those are sort of incentives for a public entity to try and reach some sort of agreement and get it right with the complainant. So this is a snapshot of the rights of the complaints that we accepted in the year 2021-22 and what rights were actually used in the complaints that were raised. The blue ones are the ones that weren't accepted. They, for various reasons, we might not accept the complaint if it wasn't a public entity that made the complaint, or if it was maybe decided to be taken under the Anti-Discrimination Act. Various things might have been considered in whether we accepted a complaint or not. But you can see that freedom of movement, recognition, equality before the law, privacy and reputation, humane treatment when deprived of liberty, torture and cruel, inhuman, degrading treatment, featured quite heavily. But there's more information, there's a lot of information in our report on the types of complaints we accepted, and also some, description of the types of what the complaints entailed. What can you do going forward to learn a bit more about how to use the Human Rights Act to advocate in your advocacy work? We've got some really fantastic fact sheets on our website. There's some more information, in terms of look at the handout, get to know those rights that are relevant to your work. Look at scenarios, perhaps, discuss scenarios that you think are relevant that have been where human rights have been limited with colleagues in a meeting, and sort of do that little activity of assessing compatibility. Think about, use those steps that I've outlined to try and assess compatibility and determine whether the public entity had a legitimate purpose and whether they could apply less restrictive measures, etc. Sign up for one of our more extended and interactive sessions, but just get more involved, more informed of the Human Rights Act, and just learn how to apply it. And hopefully, the Human Rights Act will have a better and better impact on our Queensland society as more and more people use it to advocate for their rights or help people advocate for their rights. I'm not sure about evaluations if we're going to do this. I'll leave this to the end of the session and ask Stacey to let me know about this. There's plenty of references. Also, the other references that I've used, the Human Rights Law Centre, the ACT, and the British Institute of Human Rights, and the report on the operation of the Victorian Charter. So there's plenty of information for you out there to learn about how to apply the Human Rights Act. And that's me, and I will stop sharing now. You'll get a copy of this PowerPoint later on, and I'm going to hand over to Matilda.
Thanks very much, Karen. My name's Matilda. I'm from Queensland Advocacy for Inclusion. We're a disability CLC. I'd like to acknowledge the traditional owners of the land that we're on today, pay my respects to the Turrbal and Jagera peoples, acknowledge that sovereignty was never ceded on this land. I'm a middle-aged white woman with slightly blue hair and a blue shirt on, and I use she, her pronouns. I'm the CEO at QAI, and also have a background in human rights myself. And at QAI, we run 4 major areas of practice, including human rights advocacy practice, disability advocacy practice, mental health advocacy practice, and NDIS advocacy practice. So we help a range of people with disability on a range of different matters, both legal, when we've got a fairly even split in our office of lawyers and non-lawyers. So we've got a good interaction between the legal frameworks around human rights, but also the practical ways that disability advocates in particular can use the Human Rights Act for their clients. So I've been asked to speak today to give a case study of how exactly we've done that. And I'm going to tell you about a win that we've just had this week. So it's still very exciting for our team. So Todd was in grade 8. And so I should say, under our disability advocacy practice, we have a specific education advocacy practice. So we are funded by Department of Education to help kids who are at risk of exclusion from school to get their disability needs met, reasonable adjustment, so that they can return to school and successfully engage with education. That's what the case study I'm giving today is from the work of that team. So they're all non-lawyers, but very regularly use the Human Rights Act in their work. So Todd's in grade 8 and lives with his mum and his little brother. So both Todd and his little brother have quite complex disabilities. So, Todd was having some difficulties at school, including an allegation of harm towards another student, and because of that allegation of harm, he was excluded from his school. And the school talked about there being a causal link between his behaviour that caused them the concern and his disability. So Todd's family arranged for Todd to live with his uncle because they thought he'd be able to get a bit more support that way, because the little brother also had disability and needed support So they restructured the family, and they also got additional support workers, a range of different professionals involved, extended his NDIS supports, and got him engaged with some community organisations as well. His mum, so they put in place a range of protective factors, and his mum then tried to enrol him in another school, and he was refused from that school. Now, the letter of the refusal talked about the duty of care, but did not talk about his human rights. It said things like the most appropriate mitigation strategy is to remove the risk by refusing enrolment. It said for the purpose of risk mitigation, an occurrence of injury to other students is always foreseeable and unlikely to reduce over time. They noted his young age and said that that was a cause for concern because the behaviour will only increase over time and will not be able to be adequately managed. So they really took his risk, took this idea of him being a risk because of this harm that he was said to have perpetrated as being an absolutely static factor that couldn't change, didn't take into account the supports that the mum had developed since that time, or his capacity to respond differently if he was provided with those supports. So we helped his family to make submissions, and we referred extensively to his human rights. The department, and I'll go into a bit of detail later on about what those submissions look like. So the department overturned the decision about him not being allowed into that school, but in overturning it, they didn't make any reference to his human rights. So his family then and us started to do some work to consider adjustment and transition planning to the new school. What are the things that he would need to have at that school for it to be a safe and successful environment? So the Friday before the Monday that he was due to start school, he got a notification from the Department of Education that they were proposing to exclude him from all Queensland state schools except for distance education. There's nothing new. He hasn't been to school in the intervening period of time here. This second letter then did actually have human rights, a sentence in there. It said, I have given proper consideration to human rights, including your right to education, and consider my decision is compatible with human rights. There was an attachment to this letter listing the evidence, and it just said Human Rights Act 2019 as evidence without extracting any of it. So as Karen's pointed out, that's not actually consideration in the legal sense of the word, or in a practical sense of the word. So we made submissions again based on his progress and referring to his human rights. And a final decision was made that we just found out at the end of last week, he's allowed to now return to school. So he went from being excluded from all schools in Queensland. Now he's going to be able to return to the school not his original school, but the school after that, where we were starting the transition planning. So in our submissions, and bear in mind, these aren't submissions by lawyers, these are submissions by our education advocates. We list the human rights that we think are relevant. So the right to education, the right to not to be discriminated against, and equality were most relevant here. And we considered whether or not these rights were limited. So yes, we would said the right to education had been limited because distance ed was not appropriate to his disability. So this is a kid who really thrived on attending school and having that routine of getting out of the house every day, interacting with his peers, having that routine lunch or time with his peers, that kind of school environment. And by way of example, during homeschooling during COVID, he only engaged about 20 minutes per day, and then it wasn't with anything online. It was something that had to be printed out for him. His mother had limited education herself, so distance ed and homeschooling wasn't an appropriate alternative. So yes, it did limit his rights to education, and we thought it also limited his rights to discrimination, not to be discriminated against. Given that the public entity had identified a causal link between the behaviour and Todd's disability. And I should mention this is a state school, so clearly the Department of Education are a public entity. So we said that could be either direct discrimination because he's being excluded because of a characteristic of his disability, or it could be indirect discrimination because they're kind of imposing a term that he do homeschooling that he can't do. So then, thinking about whether or not that limitation is permitted and proportionate and justified, we looked at the kind of factors that are taken into account there. So the nature of the human right, which provides all kids in primary and secondary schools with the right to education. It doesn't necessarily provide the right to an education at a particular school, but given that this was completely denying his right to education. And we looked at the purpose. Secondly, we looked at the purpose of the limitation proposed. So the limitation was said proposed because Todd was said to pose an unacceptable risk to the safety or well-being of members of the school community. So yeah, that could be said to be a legitimate purpose. But then when you turn to whether or not there's a relationship between that limitation and purpose, I think that's where a human rights argument clearly shows that he shouldn't have been excluded. So they weren't, like I said before, they were only just considering the risk at the time of the incident, of the initial incident, and presuming that risk was static and immutable and in fact presuming that it would only get worse over time. So they didn't take into account, that risk in the context of the adjustments, in the context of the additional supports, and even in the context of the finalisation of the youth justice processes. So the test for reasonable, basically they really applied like a duty of care kind of test rather than a human rights test. And we're thinking about, and there's a case in the UK, Ali in the UK, that considered the case of a kid who was excluded for a year because of a criminal investigation into an arson at the school. And in that case, the exclusion from one school during a particular period of investigation was proportionate, but there's commentary that it wouldn't likely be proportionate beyond this time and if alternative enrolments were not available. So there's a real problem there between the limitation and its relationship to the purpose. So, and in particular, that leads us to the question of whether or not there are less restrictive and reasonably available options to achieve that same purpose. So to achieve the safety and well-being of members of the school community, we said that he needs to have supports, he needs to have clear plans about meeting his needs as a kid with disabilities, and he needs to have supervision and adjustments to his schooling. And they're all much less restrictive than exclusion from all schools in Queensland. So that's the nature of the kind of human rights submissions, and ultimately the final letter allowing him to re-enroll did not reference human rights either. So you can see, even though we're actually giving a much more contextual consideration to the human rights test than the public entity, at least in terms of the documentation. And you can't always say what's going. They might be giving a great consideration behind the scenes, but that's not sufficient. They have to put it in mind. They have to, show that they demonstrate that they are considering it. So I just wanted to, so that's, I guess, a case study of how we've used human rights in a practical sense, and non-lawyers using human rights to advocate for the rights of for our clients. And what I'll just do now is talk about how another way that we've used human rights, which is in relation to a systemic advocacy. So one of the big things that I think human rights are important for is using it to change the law, using it to change systems. So not just individual advocacy, but systemic advocacy. This campaign, A Right to Learn, is a campaign being led by QAI and a number of other different organisations, aiming, because we did a right to information application, finding that nearly 50%, so 47% of kids who are excluded and expelled from schools in Queensland have a disability. So we are calling on the government to halve the number of kids with disability who have been excluded and expelled within a 5-year period. And we're also calling for transparency and accountability around that commitment. So a publicly available scorecard, a parliamentary inquiry, an independent board set up to oversee progress towards that commitment, and multi-tiered systems of support that will then provide the evidence base behind what do these kids actually need. So as you can see in our systems campaign here, it's called a right to learn. We're focusing rights very strongly, and education is a right is the first thing that we've got here. So all children have the right to education. We also talk about support, not punishment, and inclusion benefits all. So we'll send around a link to this, and I encourage you all to pledge your support by taking the pledge to support for disabled kids to stay in their classrooms, and have a look at a key ask there. But yeah, using human rights as a very foundational tool. The government has committed to them. We need to use them both in terms of our individual advocacy, but also in terms of our systemic advocacy. Thank you, Stacey. That's all I have.
Fantastic. Thanks, Matilda. And thank you to Karen too. I just saw a lovely comment from Jenny in the chat about this being a really practical session for organisations. And that's fantastic to hear, because that is our intention behind Human Rights in Action, is really bringing the Human Rights Act to life, acknowledging that sometimes it's really hard work to take a piece of legislation or an act and figure out how we actually honour it in frontline service delivery, in our policy decisions, in our practice. So really good to hear that this has been a helpful session. I wanted to mention that earlier this year, one of our Human Rights in Action webinars that, again, we had the pleasure of hearing from one of Karen's colleagues from the Queensland Human Rights Commission and a lawyer from Clayton Utz about what does proper consideration actually look like. And Matilda and Karen have both touched on that really important element of having evidence for proper consideration. And it is more than having a sentence in a letter that says, I've given proper consideration. So I've popped a link to the recording to that session where we did actually have a look at what that evidence actually looks like for organisations, for functional entities. So please check that out. And as we have mentioned, there's going to be plenty of resources in the post-event email with the slides and the various things that we have referred to during the session today. But we do have 13 minutes left in our session. So was there any questions or comments that anyone would like to put forward?
Stacey, I noticed a question in the chat from Joe, who is asking if there's no outcome from Queensland Human Rights conciliation process, there's no further action that can be taken about the complaint. So that's pretty much the case, Joe, and you've yourself nailed it, that unless it's under the Anti-Discrimination Act, but the ability for the Queensland Human Rights Commission to publish information, if if it feels that a complaint's been made and it's an important complaint and there's no outcome, it can publish information on the website, and most public entities are not going to want to have that happen. So that's a bit of an incentive for outcomes to be reached by the public entity, and even if it's not published about an individually, it will be in the report, and public entities are not going to want their complaints again and again every year, having loads of complaints against them that are noted to be unconciliated. So hopefully, as time goes and as they get more, as there is more advocacy work, then there will start to be more conciliated outcomes, or even better, complaints resolved in that dialogue with the public entities. No need for a complaint to the Queensland Human Rights Commission. But you're right, there is no further action that can be taken unless the complainant then decides, well, if they want to then go to the Ombudsman. I think they probably can't.
Thank you.
Matilda might have more information on that. I don't know.
I just want to mention, if you would prefer to speak rather than type, please just put your hand up and I can take you off mute. But I can see here there's another question from Kath. Kath says, I'm in regional Queensland and often am told that the public entity doesn't have the resources to fulfil human rights, especially in community health and mental health. How do I address this? Really, really good question. Complex.
I think the argument, so when you think about it, they have to have a legitimate purpose. And if the only legitimate purpose that they say they have is, oh, well, we've got to fit within budget and resources, that's not a great argument for them in terms of legitimate purpose. If that's the only argument they've got, I mean, look, if it's a school, a small school, and they've already got 5 kids with disabilities, and they're just saying, look, at the moment, we just can't get anything from the department in terms of extra support or whatever, maybe they've got an argument, but limited resources often, in many cases, not going to be a sufficient argument for a legitimate purpose. I don't know, Matilda, do you have any thoughts on that?
Yeah, I mean, I think my thoughts are we've got one Human Rights Act in Queensland that applies equally to every Queenslander, no matter where they live, no matter their race, religion, or disability. So it is the case that services might be more expensive to provide to people who are regional or people who are have disability, or a range of different other attributes. But that is not something that is an excuse under the Human Rights Act.
And I guess this goes back to, again, organisations being able to evidence the proper consideration. So having some evidence there, this has been a really hashed out, unpacked issue that they have, and there has been adequate, proper consideration given to the issue. I mean, resourcing is a challenge for many organisations, more so in regional areas, but it's common, particularly with the workforce challenges we have at the moment. So I think that organisations that have gone through the proper consideration process may find some solutions through that process.
And I think maybe there's a more systemic argument to be had there. If the argument is again and again a legitimate argument, we just don't have the resources, well then, a campaign such as QAI's campaign about every child's right to education, that's a campaign at a systemic level to the department. That's where, sometimes those campaigns for more systemic changes, well, we need more resourcing. We can't have people, sleeping on the streets, or kids not being able to attend schools, etc., etc. Then using human rights in those systemic change campaigns is useful also. And it's not a silver bullet. There's no silver bullet. It's going to be hard work, folks. We're going to have to plug away and use it and keep going and keep on using it to make change. So some of those changes are going to be difficult, but, we have to keep going with it.
Yeah, that's all right. A conversation we were having in the office this morning is, we've learnt the answer to all the queries we get about the Human Rights Act, and the answer is this: it depends. And we're constantly, all right, but what about this? And it's a constant assessing. But what a great skill for our sector to be developing our capacity and being able to critically think about scenarios, their uniqueness, and weighing up how we give proper consideration to the rights of all individuals. So not at all a though Karen, you've said it's a tough one and it takes a lot of energy and it does take thought. Certainly not a bad skill for us to all be developing in our professional and private lives.
And when you have that win, like QAI has just had that win, how amazing is that? And that's going to impact more than just beyond that, just that individual child. You're muted.
Yeah, sorry, I just said yes, that's right. I'm just wondering if there's any other questions or comments before I make some final comments. Just let me know, or put your question in the chat if you do. Look, I I want to thank Karen and Matilda again for their expertise and sharing their learnings with us. It's been really beneficial for all of us on the line. Please keep an eye out for that post-event email because it will have lots of links in there for you to refer to. And this week we're going to have our first newsletter around human rights in action going out from QCOSS. So we've got a few interesting pieces in there, including an article all about the effectiveness of things like the Human Rights Act when they may be overridden. And you've guessed it, we're talking about youth justice and the new laws that have come into play. And if you're interested in that issue, we will be holding another Human Rights in Action session later this month. And we're taking registrations now. So I'm going to pop that in the chat in case you're interested in that particular session. We are going to be talking about alternatives to the youth justice system. We believe that there are alternatives that have better outcomes for children. We believe that that's possible, and we're going to have a few different speakers talking about their ideas of how we could better respond to children who are entering the youth justice system. So please come along to that if you're interested in that topic and having a discussion about applying a human rights lens to laws. And now we're going to the word's gone from my mind. We're going to put the poll up for evaluation. We'd love to hear your thoughts about how you found the session, because we do put these on regularly and we're really keen to hear about what is useful for you. And if you have just any general comments about what you'd like to see in the future, please put them in the chat. We're really happy to hear from you and to take your ideas on board. And I really hope you enjoy the rest of your day and this week. And I hope you all cope with your 5-day week next week after having all these 4-day weeks, because I'm not sure how, I think every year this gets us. I'm not sure how we're going to all cope with it. But anyway, maybe one day we'll be able to shift one of the public holidays into a different month so it doesn't catch us all out. Thanks for joining us. It's been a pleasure to see you all on the line. Thanks for your questions and for your time. Thanks,
and thank
Karen,
you,
Matilda.
Stacey. Thank you, Stacey, for organisation extraordinaire.
Oh, my pleasure. I learn something new every time. And we'll be really keen to have you back again. And for anyone who's interested in the campaign that QAI is taking great carriage of, we'll have the details of that in the post-event email. Would really encourage your signing up to that to see how it goes, and you can learn more about how advocacy works in this space. Thanks very much. See you later.